Hey guys, Brian here with Stogie Review. I am here with Frank Herrera. Hey Frank, how you doing?
I'm doing great, Brian. How are you?
Not too bad, not too bad. Now that we've worked through some technical issues, I hope. So you're going to give us the scoop, the latest scoop on the FDA and the regulations that are going to be affecting the cigar industry. And well, I mean, my first question is: did the sky fall? Did the eighth really mean what we thought it meant, or did the date change and just not hear about it?
Yesterday was the official date, or what they call the effective date of the deeming regulations. Contrary to a lot of popular misbelief, there wasn't a lot that actually went into play at that time. Some will argue with that, but the most important thing that went into play was applied to retailers. Um, did the sky fall? I think it's too early. I think there are a lot of questions to remain to be answered by either litigation or legislation. But in the meantime, manufacturers, clients of ours, importers, everyone else, they're preparing as if this is the new normal.
So you said it was mostly things that had to do with the retailers. So what's going to happen with the retailers? What do they have to do now that they didn't have to do?
I'm not sure if you can see my screen or not. I'm not sure if we're sharing that or not, but I'm going to bring up kind of a little cheat sheet that we use that will effectively, well, kind of break down for you what's going to happen or what happened yesterday for retailers. Okay. As of yesterday, cigar retailers are prohibited from selling to anyone under the age of 18. Now, that might not sound like a big deal because most state law already addresses that. This means that it's essentially a federal law, federal crime for them to sell under someone under age 18.
Okay. I had heard that there was some weird loopholes where that wasn't in effect. I think most people believe that that was kind of the law of the land everywhere.
Yeah, well, it's kind of goofy, but the added language, which makes no sense at all, requires that a cigar retailer must check the ID of anyone under the age of 27 attempting to purchase a cigar. So, I mean, knowing what somebody looks like is very subjective, and the fact that someone's under the age of 17 but over the age of 18 makes them legal to purchase anyway. So it's really a nonsensical aspect of the deeming regulations. And
It's kind of
it also begs the question: how do you do that when it's an online purchase?
yeah, kind of hard to do that, right? I guess there's probably going to be a one size fits all type of thing that they force everybody into. I'm guessing online
Mhm.
orders, you may have to provide ID, perhaps. I mean, that would like scan it and send it in, maybe set up
Yeah.
an account.
Well, there are some age verification plugins for online retailers, and also deliveries where there's age verification. There's some things for online retailers, but the deeming regulations do not go into great detail as to how online retailers could comply with this law. One of the other things that's as law as of yesterday is a complete ban on free samples, and there's a lot of discussion, a lot of rumors as to what this means. The language as it applies to retailers is a retailer is prohibited from providing anyone a free cigar sample. And from the language of the deeming regulations, they say a customer can smell and inspect the cigar. However, they cannot light the cigar without first purchasing it, which is kind of silly. So some of the rumor and misinformation or disinformation about this is to what extent are free cigars banned? Can a manufacturer not give a free cigar to a retailer, et cetera, et cetera? And we think it's a ban on free samples, just as it says, but as long as there is some type of sale tied in. So, for instance, buy 10 boxes of cigars, get one box free. I don't think manufacturers can say that to a retailer. I think they'll basically say you bought 11 boxes, but the discount applies. And essentially, the discount is such that one box would effectively be free.
That
That's
makes sense. I was curious about that whole free sample thing and
Yeah.
wasn't sure, as I think a lot of people are, whether that's retailer, manufacturer, one or the other. But I know definitely retailer. And I even wondered,
You're
is
breaking
there
up on
an
me, man.
issue? Is there possibly an issue with one guy giving another guy a free cigar? Is it possible that they could get in legal problems if I just gave you a cigar? Either of us are
No,
retailers.
no,
Well,
no. I don't think there's any ban on that.
okay. Yeah, I figured not. It seemed a little excessive. It's kind of
No.
hard to control it at that level.
Right. So the act is really called the Tobacco Control Act, right? So they want to be able to control tobacco cigars from manufacturing to the end consumer. That's their biggest concern.
Okay. So did you have more things on that list you wanted to go through, or was that the
Yeah, no,
extent?
no, no. There's some more for sure.
Okay.
So there's warning statements. Now we know that warning labels are going to have to be applied in a couple of years by the manufacturer to the boxes, but a retailer is going to have to put a warning sign um, at the point of sale, and I
Oh,
believe it's
really?
effective as of today, yesterday rather. So it's going to have to be of a certain size, and it's going to have to be within 3 inches of the cash wrap or the cash register, and a couple of other details. This is also going to be applicable if retailers sell cigars individually. That is, they take them out of the boxes and then individually market them or display them. A retailer will have to have its own sign placed giving a warning in one of the 6 warnings that are listed in the deeming regulations.
So, for example, what about the? I know when I've been down to like Miami, South Beach area, or whatever, you've got girls that run around with trays that have cigars and stuff on them. Will they? I guess they'll have to have a warning on that tray to sell the cigars the way they're doing it in
Yeah,
order for that to work.
yeah. Essentially, wherever it is at the point of purchase, there's going to have to be some type of warning label. So the initial, as we said a minute ago, the initial warning requirements, the burden is on the manufacturer, and it would have to be on the 2 primary display panels of the cigar box. But once it gets to a retail shop and that retailer sticks his hands in that box and removes those cigars, he then has to have a warning label, within a certain distance of those cigars, so that the consumer is there after warned again. Uh, of one of the 6 warning statements.
So, so when a retailer takes, for example, this happens at my local shop, takes the cigars out of the box and puts them in one of the trays,
Mhm.
that's okay as long as they put warning labels on the trays, or do they? Is just having the one at the register adequate?
So I think initially the first warning is at the cash register, but I believe when the warning labels apply in 2 years, I think the latter is going to be applicable for retailers. Okay, does that make sense?
Okay,
So there'll be a primary warning at the cash register, and then later, when the warnings are applied to all cigars, they'll have to do that next to the display that they might have in the humidor.
I see. Okay.
Mhm. All right.
So, on the subject of were you going to cover this? I'm not sure, but I know that I was told that the bargain bags that a lot of retailers sell, where they put cigars together into a Ziploc and put a discounted price on them just to basically move product or whatever. Uh, I was told that that's not legal by
Well,
my
so
local
that's
shop.
that's true. So effectively, the deeming regulations have a very broad definition of what a manufacturer is, a domestic manufacturer. And it's essentially anyone who relabels or repackages, reconfigures even a tobacco product, a cigar product. So in your example, if there is a retailer that likes to, for whatever reasons, they want to, take 2 of these, 3 of those, 4 of those, and put them in a Ziploc or what have you, they have effectively engaged in manufacturing according to the broad definition of the deeming regulations. It's ridiculous, but that's the case. So anyone that's doing that now is engaged in domestic manufacturing, and it's basically a no-no, which I think is ridiculous, and I think that should be changed and altered in some shape or form, whether it's in litigation or discussions with the FDA. Additionally, retailers who engage in private labeling their cigars, they have a friendship with a manufacturer, and the manufacturer sends them bundles, naked bundles, or even sends them the cigars with their own kind of house blend brand on it. They're now a domestic manufacturer, so that they
Oh,
would,
really? Okay.
yeah, yeah. So they would be required to register their establishment by the deadline of the end of this year. And if they want to keep those products in the marketplace, they'll have to go through one of the pathways, whether it's a grandfathered or substantial equivalence report. Most likely not exemption. Exemption is going to be available in very limited circumstances. So it's either grandfathered or going to be subject to a substantial equivalence report.
So even yeah, so if they were doing it before the February date in 2007, they would have
Yeah.
the opportunity
So
to do the grandfather potentially.
yeah. So, this is a big deal. The retailers, the consumer may just think, oh, a retailer just sells, XYZ brands. But the truth of a retailer business is a lot of their margin and profit comes from their own house blend, house brand, or even kind of clearing out the dead weight, the dead wood in their humidor by taking one of these, two of these, three of these, and put them in a sample package. And that is going to be problematic for the retailer. So retailers should pay attention to this. And so when is it? Why is it a problem? I don't think it's a problem today, but there will be inspections by the FDA, and they'll be unannounced. And they will come in and they'll see if a retailer is in compliance with the various aspects of the deeming regulations. And if they see that a retailer is selling these sample packs or selling a product that is mislabeled or not registered with the FDA by the deadline, we haven't passed those deadlines yet, then the retailer could be on the hook for some civil liabilities.
So out of curiosity, with the bargain packs, I'm curious because I'd heard of a way of potentially getting around it that might work in lieu of actually putting it in Ziploc. That would be to I don't know, have a listing of pick X number of these cigars together, and the price is that the by not physically separating them out into the bags, does that meet up with the legal requirements, or are you still
No,
potentially running afoul of the law?
I haven't heard that angle, but it doesn't surprise me, and actually, it's kind of interesting. I think as a retailer, you are inclined to sell your product as you like. So
Yes,
as long as you're not engaged in what they call manufacturing, which we all know is not, but that is choosing certain products and grouping them together and repackaging them or relabeling them. As long as you're telling people, hey, XYZ products are on sale and you choose how you like, then I think that takes that out of that kind of definition. Don't take that as the gospel right now. I've just kind of come across that point, but it seems like the FDA would be hard pressed to tell a retailer that they're engaged in manufacturing. In fact, all they're doing is retailing, saying we're getting rid of these.
exactly.
Yeah, so you pick and choose any five or whatever. It's up to you.
Yeah, and basically, you'd organize the discounts, the discounted cigars onto a shelf and just pick
Mhm.
X number, 4 or 5 of these, and we'll supply you the Ziploc bag. We'll sell that to you for a dime or something like that.
Yeah, I don't think that's the greatest concern. I think the FDA, again, it's called the Tobacco Control Act. They're just trying to find some control. It's an industry they don't understand. They don't understand the manufacturing. They don't understand the retailing. They don't understand any aspect of it. So I think as time goes on and they learn from the reports that we're filing, or they learn from their visits to retailers, I think a lot of the issues that are actually really important will flesh out, and the ones that aren't really that important, they just won't care about, right? They'll just overlook.
Yeah,
So right now, everyone's freaking out because the language is so broad, and it's actually and a lot of times irrational. A lot of the language in the deeming regs is really irrational as it applies to the cigar industry. I think people are just kind of freaking out. What does it all mean? What does it all mean? And we don't know. We can give you some guidance, but until time passes and the FDA learns the industry and we learn what's important to them, I think we can provide better guidance as to what it all means.
so you had mentioned some dates coming up, but what are some of the relevant dates you've got by the end of the year to have registered product. Is that what you were saying earlier? And I don't know if there's some other significant dates on the horizon that people need to be aware of.
Yeah, well, so it's all depending on where you are in the chain of distribution, I guess. So the quickest, the soonest, the earliest deadlines, apart from the effective date of yesterday, importers have a deadline of August 20th of this month to report their imports to the FDA. And the reason that the FDA is requiring that is they want to find out who these importers are importing for, what the taxes were paid, and they want to identify the persons or companies in which the importers imported for. And that is all for user fees. They want to be able to figure out, calculate what they think the user fees are going to be for the manufacturers. So that's the first deadline applicable to importers. If you're a manufacturer, a domestic manufacturer, you most likely are going to have a call from your importer, if you're not your own importer, discussing this deadline and the fact that user fees will be assessed against the manufacturer soon. But as for this year, the most notable deadline is the end of the year, December 31st, and that is for what they call establishment registration. And that's essentially, you say, hello, FDA, my name is XYZ. I'm engaged in domestic manufacturing, and my warehouse is located at XYZ. Here's my address, here's my phone number. And then you also have to submit what's called a product listing. And the best we see that as a submission of all the products that you are marketing, selling and marketing. So it'd be like price lists, photos of your products, just to give the FDA an idea of your company and what products you sell. Thereafter, the FDA will contact your importer and tell them what your user fees are going to be, and you'll get assessed on that. Thereafter, go ahead.
So who's going to do? So you're supplying the importer with your user fees. So you're paying your user fees to the importer, who will then pay them to the FDA or whoever.
Right, that's the best we understand right now. We understand that it's the importer is going to be on the hook for it initially, but of course, if you want to continue to do business with your importer, you're going to pay your fair share, right?
Absolutely.
And so a lot of importers are concerned because depending on how sophisticated an importer you are, when the imports come in and you say, hey, XYZ manufacturer, here's your product, here's your bill for the product, for the S-chip, for the broker's fees and everything else. And by the way, here's your user fee assessment. You know, some of the smaller guys are concerned that they're not going to have the cash to pay that at that time. But it's really based upon how much you're importing. So if you're not importing a lot, your user fee is not going to be a lot. So it should just be another kind of line item that you pass on to your end consumer. And we think it's going to be about 4 cents a stick.
That's right. You'd mentioned that before. Didn't you say it was going to be a range between, what did you say? It was like 2 to 8 or something.
2 to 6. So we say 4, right? Yeah.
Say
And
four,
we don't know, and it may change entirely, but that's based upon what the FDA is guessing as well.
Now, did I cut you off on any of the other things that were going into effect on the 8th? I guess that was yesterday.
So yeah, on the 8th, there's also you can't have a mild, or the terminology is not mislabeled, but the terminology is escaping me right now. Essentially, you can't mislabel a cigar or market a cigar that has any type of mislabeling on it. So if it is, then it's subject to removal or compliance issues.
So when you say mislabel, you're talking about light or mild or anything implying health, something
right.
like that?
Modified risk, right? Any kind of language that discuss modified risk. So that would be barred at this time. So you might have read that the makers of Black and Mild sued the FDA in the District of Columbia, United States District Court, District of Columbia, and they just settled that suit because Black and Mild contains the word mild, and their argument was, well, mild is part of our trademark. It's not a modified risk descriptor. So it looks like FDA kind of backed down on that and said, okay. Yeah, yeah. So they're allowed to continue to sell black and mild is not a modified risk descriptor.
So does that, and I'm going to use the word before again, and I used it before incorrectly, but is that any kind of a precedent type of thing, or does it set the stage for other people to be able to at least use that term? Or
Well, it all depends on how you're using it, right? So I haven't completely digested that opinion. Well, it's not an opinion; it's a settlement. But if I had to guess, they said, hey, we have a registered trademark. It includes it. We've been using it forever. Consumers don't view it as a modified risk descriptor. It's just a trademark. So if I were to come out with, whatever, white and mild, well, I could use that same argument, except for the fact that the owners of black and mild might have a problem with me. So now I
yeah,
don't have an FDA problem. I have their problem. So, but the point is if you're using some of these words that they don't want you to use, but you've been using them as a trademark, then I think you could at least go to the FDA and say, hey, you took it easy on black and mild. We have the same arguments essentially.
do you have a complete list of those words that they don't want you to use, or is there a complete list?
I'm not
Just
sure if
kind of,
there's a complete list of them, but they do give examples of those words. And low, light, mild, things like that. So
I gotcha.
you don't want to give, what they're saying is we don't want to give the false impression to a consumer that one cigar is less dangerous to their health than another. So you might have, the Frank Herrera biography line, and one is low, light, and mild. And they say, well, a consumer may choose low because they're trying to kind of wean themselves of cigars, or they don't want to be as harmed as much as maybe a strong cigar. So they may choose low, where in fact there was really no language before that kept manufacturers from using those terms. You could use them any way you wanted to, right?
Huh, interesting. Did not realize that. So,
Yeah, yeah.
but if you're describing body somewhere in the advertising or the right, uh, any kind of documentation that's around the cigars, if you say it's a medium body or mild body or something like that,
Mhm.
is that now out because that possibly implies less risk to somebody, or is
Well,
that still
yeah, well, they want the manufacturer to refrain from that. So as a writer, as a journalist, I would argue that you're free to call anything you want because you're not the manufacturer. It's just your opinion. It's your journalistic, point of view that something is mild or medium or whatever the case may be. But they don't want manufacturers or even retailers, if they engage in manufacturing, to use these terms in connection with their product packaging or advertising.
okay? Makes sense. Makes sense. Now you had mentioned earlier, and stop me if there's additional things that we need to discuss regarding the eighth here, but something I did want to get into that we talked about earlier was the potential impact of all the vaping stuff, the lawsuits and whatever they're doing on
Mhm.
the cigar industry. It sounded like there's some we might actually get a little bit of a windfall perhaps from that, right? Is that my understanding of that correct?
Yeah, it's possible. So Nico Pure is a vape company, I believe, out of Tampa or whatever, and they filed one of the, if not the first lawsuit against the FDA. I think it was actually May 10th, the date of the publication, in the United States District Court for the District of Columbia, and then thereafter like a state interest group for vaping industry filed a lawsuit thereafter. And those actions, the court actually consolidated the actions. Although they had slightly different arguments in their complaints, the court said, hey, I get it. Nobody likes the FDA. You're vaping. Let's consolidate, for judicial economy purposes. So long story short, their arguments are different than the arguments brought by the IPCPR, CRA, and CAA, and as well as my client, 1502 Cigars. However, they do have some arguments that might be applicable to our litigation. So one of their arguments was about the grandfather date being too long ago, 9 years ago. Vapes really only came after that time period. It's not fair, all of that. So the court, in that case, did consolidate the cases and required the parties to file expedited summary judgment motions. Usually summary judgment comes months and months after a lawsuit is filed. The court, allows for some discovery, allows for the parties to kind of discuss and engage in some litigation. But the court expedited the requirement for summary judgment. Most likely because it's a DC court that deals with a lot of agency decisions, and there's probably not much in the way of discovery. So the court wants to see if it can just resolve it in summary judgment. Long story short, and I think the response has not been filed yet by the FDA, but it's due soon if it hasn't been filed yet. The hearing on that will come up in the next couple of weeks. I don't have the date in front of me, but I know it's soon. And then that court will have an order issued on that. And if the court, in the best case scenario, has some language in the order that says the FDA was arbitrary and capricious in selecting that grandfather date, that would be very effective for us, because we can go to our court and say, hey, judge, and the IPCPR can do the same, and they're in the same court, by the way, DC. We're in Miami. We'd say, hey, this judge, who's a well-respected judge, determined that the FDA was arbitrary and capricious, at least on this point, and we can use that as some ammo. Now, obviously, the vape companies are not arguing some of the other things that we're arguing about, like the size of the warning labels and things like that. But I think if the vape guys do get something that is sufficiently positive and negative for the FDA, we can certainly use that as ammunition in our fights.
Yeah, that'd be great. That really would be great. Yeah, I was just thinking, that reminds me, what was the Small Business Act you were talking about that's potentially would come into effect there? I mean, because you would, if the grandfather date stayed the same, it would virtually obliterate that industry. And Small Business, what was it, Flexibility Act or something like that?
Flexibility Act, the Regulatory Flexibility Act, which is basically known as the Small Business Act. So essentially, years ago, a law was passed that said, hey, if there's any agency decisions that come out, they have a duty to engage in some type of analysis as to what the effect will be on small businesses that are in that particular industry being regulated. And so one of our arguments, and also the arguments of the IPCPR, and even in the vape cases, is that the FDA did not follow that law, and their analysis was not the proper analysis. And because of that, their deeming regulations do have an inordinate problem, or it's just basically going to wipe out small businesses that are engaged in these.
I'd say industries. It's an obliterative. That's not even real. Never mind. Yeah. I'll say that.
But that's the point. The point is hey, you can have your agency decisions, you can do anything you want, but you have to follow the rules. You can't just ram something through and say it's one size fits all. Now, if you've properly considered all the positives and negatives, and then said, yeah, we don't care if it has this effect on small business, but it's very important, then we're fine with that. That's, you follow the letter of the law. But when these deeming regs were circulated, the Small Business Administration, which actually by law is almost like a watchdog for these agency decisions, they actually received a copy of it and sent a letter to the FDA saying, we believe that you're violating the Regulatory Flexibility Act, and you should conduct more analysis and do this, that, and everything. And the FDA essentially said, we don't care. We think we're right. Thank you very much. Goodbye. So we used the communications between the SBA and the FDA in our lawsuit, and I believe the IPCPR, CRA, and CAA did as well. And I'm not sure if the vape companies did as well. But we essentially said, hey, we're not just making this up. We're not just crazy lawyers that's just trying to have keep our cigars. But we're pointing to the SBA, Small Business Administration, that agreed with us, or actually said it before us, that said, hey, the FDA is not following this law. So we think that the court or any judge will take a look at this and say, I see it for what it is. It's an agency decision that was rammed through without due consideration of the fallout. Can cigars, vapes, e-cigarettes be regulated? Absolutely. That's has been decided. The Tobacco Control Act said you have to control tobacco and various things. But it has to be done in a way that's consistent with the law, that's consistent with the Regulatory Flexibility Act, that's consistent with the First Amendment, with the Fifth Amendment, and every other law that might apply.
Great, great. Yeah, I'm sounds like that's a got a pretty good chance of helping out,
Yeah, I think,
reducing
listen, yeah,
burden.
I think we have something. And when I say we, I mean the cigar industry, not necessarily just our case, enough to at least to go to a federal judge and say, hey, there's a problem here. Now, I don't think the judge is going to say, hey, just go away. We think the FDA is perfectly right in what they're doing. I think the court is going to consider, these arguments and what they say or do thereafter, who knows? What they might do is apply pressure to the FDA to reconsider some of these things and then give them remand this to the FDA so that they can further consider and amend the regulations. I think that's a possibility. And also the FDA could always come to us or IPSC or whatever else and say, okay, we can carve out certain things. We think this can change, that can change. Right now, the FDA says it doesn't have any power to change the predicate date. I don't believe that. No one else believes that, but that's their position.
Oh wow, didn't realize that. So is there the real possibility that the judge could tell you just to take off and say, "Hey, I've looked at this and no, we're not even thinking about it." Is there a risk there of that?
It's possible. I think the court, if the court agrees with the FDA that it doesn't have the power to amend that date, then the court will have to determine that the Tobacco Control Act did not afford them the right to go back 9 years. So they'll have to be consistent with the Tobacco Control Act. Other kind of lookbacks for cigarettes, roll your own, everything else, and the history of this has been about 2 years. So, for instance, Tobacco Control Act was 2009. The look back for those folks, cigarettes, et cetera, was 2007. So 9 years is a long time. A lot of clients coming to us, when I explain all this, they're like, we don't have any records for 9 years.
Yeah.
We're not required by this, the IRS or anybody else to keep records that long. Or they'll have some, but not all.
Yeah, that's a really good point. I didn't even think about that. With the IRS, it's what typically like 7 years you're supposed to hang on to your documents, something
Sure.
maybe,
Yep. Yep. And,
if that, actually.
so they put you in a situation where it's like the burden is on our clients to prove commercially marketed on February 15, 2007 and prior if they're going grandfathered, but they may not have anything. So they have to look to see if maybe Cigar Aficionado Insider did something, or a blog such as yours may have written about it, or a retailer might have recalled it and has invoices, for some reason. So it's this whole kind of what we've been doing the past couple of months here is really trying to put the puzzle together for clients. Okay, what do you have? Well, I have this, this, and this, but not this. Okay, well, let's go here. So we've really told clients, here's what we're looking for. Go out, do your homework, come back to us with what you think you have to substantiate that you have a grandfather product. And then we'll have to work together to find other sources that might substantiate, that this is in fact a grandfather product.
That's basically kind of forensic work. You need a private detective and stuff to go searching for records of your own products going back
Yeah.
9 years.
Well, and then it's further complicated because of many clients or many in the industry are post that date. So they have products that are not grandfathered. So
Yeah.
now they no problem finding documents of commercially marketing within this window post 2007 but pre 8816. But now they have to find a product that a predicate product that they can compare it to if they're going to do a substantial equivalence report. So they're going online, they're talking to their manufacturers to see if the manufacturers has a predicate product. So now it's like, okay, well, we know we're okay, we're pre 8816, but what are we going to compare our product to? And then the other big question is if and when we submit this to the FDA, is the FDA going to consider all this information and say, yeah, we find your product to be substantially equivalent to XYZ's grandfather product? There's a lot of unknowns.
Oh, I didn't even think about that. I was thinking all the grandfathering and the substantial equivalence had to be within the company. But if you can somehow tie your product to somebody else's product that's been around, you still have the potential to have that substantial equivalence, even if your business has only been open for like 2 or 3 years.
Yeah, you definitely can do that under the substantial equivalence reporting pathway. For
That's
exemption,
kind of huge, actually.
yeah. But for an exemption, you can't. For an exemption to substantial equivalence, you must own the predicate tobacco product. But most cigar guys are not going to be able to get an exemption because that's like additives. That's anything except changes in tobacco and water and glue. That's other things. So most,
Okay.
yeah, most post 2007, pre 8816 commercially marketed products are going to be substantial equivalent reports, which are due February 8th, 2018. So they get about 18 months from yesterday.
Okay.
Mhm.
File those. Any other dates coming up?
So next year there's going to be an ingredient listing date. We're not 100% sure exactly what they're looking for there and how much we need to give. There's going to be a deadline for warning plans. You're going to have to submit your warning plan to the FDA, which essentially tells them, hey, we understand there has to be 6 rotating warnings. This is when we're going to do it. This is when we're going to switch it out, etc. There's also advertising plans. Those don't go into effect, I don't think, until next year or the following year. I have to look at my cheat sheet. But again, you're going to have to tell the FDA, hey, I plan to advertise in Cigar Aficionado for 6 issues, and we think it's going to be a 1 page, and et cetera. Or we advertise online, and we're going to try to put our warning labels online when that's required. So manufacturers.
So you have to tell them. You have to advise them when you're planning on advertising your own product. That's interesting. I had not heard that yet.
Yeah. And then you're also going to have to stay in touch with them. You're going to have to update your information with them on a
You have
constant.
to friend them on Facebook too.
Well, don't get me started. They're not very responsive to communications, emails, and phone calls and all that. We've been going through that for several months with them.
Does that work to their advantage to not be responsive? Because if they don't respond, that just ties things up, and all these dates can keep marching by, and they don't have to really address any
I don't
problems with
know.
their.
Yeah, I don't know if there's 100% ill will there. I just think it's a large governmental agency that really thinks that their guidance documents and everything else kind of speak for itself, when in fact it doesn't. They've only issued a few guidance documents as it relates to, to the deeming regs, and they're nonsense. There's nothing in there that you can't read in the deeming regs. It's not explaining anything that's of any significance, at least for us. So deadlines are very important. Obviously, we have them all in our system. We're advising clients, potential new clients, about what they are. We give them a whole package. We're also giving them spreadsheets so they can do their own homework on identifying their products, when they were introduced, how they were introduced, what documents are supporting their use in commerce, whether if it's a substantial equivalence product, what predicate product they might be relating it to. So right now, all our clients are doing their homework, and they're looking everywhere possible to kind of build up their file. And we're telling them to hold off a couple of months before filing these because we want to see what happens with the litigation or the legislation.
So how long you figure that's just like 2 months before you'll have an idea of where that's going?
We're not 100% sure. It could be a couple months where we get at least some indication of what court's going. It could be that the court in the vape case basically tells the vape people, you're full of it. The FDA is awesome. Don't even worry about it. It's true. It's possible they could do that. In which case, we'll tell our clients, hey, let's just go ahead and start filing these things because it doesn't look like
FDA rules, man.
Yeah.
I should edit that out.
Nah, it's fine. I'm sure they'll watch this. These videos are more entertaining than their webinars. I don't know if you've watched any of those, but they're a complete waste of time.
No, this has been way more informative than anything written or anything else I've seen.
Thank
Laying
you.
it out pretty clearly. You're good at what you do, it turns out. Who
Nah,
knew, right? So before I forget, tell people how to contact you. I'll put it in the post whenever I get this all set up, but
sure. So
let them know.
Facebook, you can contact me personally. I take a lot of calls or contacts, texts, whatever, personally. I get a lot of people contacting my cell phone. I'm trying to get away from that. So if someone that doesn't know me wants to contact the firm at 561-841-6380. And then the firm name is hnewmedia.com. It's a terrible website. Yeah, it's
No,
terrible.
I mean,
But that's the best way.
does it need to have a sexy name? You don't want, been hit,
The funny
type of
thing is
lawsuit thing.
I never liked lawyers, and then I went to law school because apparently that's all I'm good at. So, and I worked at law firms with names of this guy, that guy, and the other guy and lady, whatever. And I never liked those names. So 5 or 6 years ago, when I went off on my own again, I figured I'd just come up with some short, goofy name that has, I don't know. There's just something weird about law firm names. It's always turned me off because I see ourselves more as business consultants rather than just straight up, lawyers. And our philosophy has always been, if we don't kill you on prices and we give you good advice, then your business grows. And when you grow, you give us more money. So it's
It's good
more of
policy.
a real long-term relationship. We've had clients for 15 years, many clients for many, many years, just because we don't kill them on prices and we just try to be fair. That's all. Just the golden rule, I guess.
Yeah, no, that's great. So anything else we missed? I think I went through all the things I could think of.
Well, I mean, there's the devil's in the details. There's tons of things going on, but I think that's enough to kind of give folks an idea of what's going on. Retailers, wholesalers, importers. Don't believe everything you read on the blogs. We are attorneys, and we're held to in a higher ethical duty. Our license is on the line. We do our best to try to explain the laws. We understand it. Just be careful of people promising to, give you legal services if they're not licensed as an attorney. You don't have to hire us. I mean, I know this is a big commercial for us, but do hire somebody that has experience in this because your livelihood is really at stake. If you screw this up, then there's a very good chance you'll be out of the cigar business or pipe business or whatever else.
Yeah, exactly. Well, thanks so much for spending the time to make this video possible. I think it's been awesome. I like this video more than the first one, and hopefully it's reasonably without issues with video and audio. And, really appreciate your patience getting this video going because we had some technical difficulties. And
Yeah, no problem,
Frank
man.
is immensely patient. That's one thing. It's it's one thing you've definitely got going for you. You've got patience, man. You've got the patience.
You gotta have it, man. I gotta have it. So I appreciate the time, and if anybody has any questions, just contact me, email, Facebook, text, whatever. We get messages any way that people get messages these days. So
What's the law firm's email address?
it's so the best way is probably my first initial, my last name. So F Herrera, Herrera at hnewmedia.com.
Great. Well, thanks again.
All right, appreciate it. Take care.